because we're very glad that he came anyway, but we're even gladder that he's not only giving this talk over lunch, he also taught yesterday right out of the plane in Professor Kuhner's class on human rights, and right after this talk, he'll go on to teach in Professor Kuhner's class in public international law. So really making him work hard for his visit here. We're very grateful that Jean-Marie Henckaerts is here. You all know and have seen, I hope, on the website, he has a legal education from Belgium, from Brussels, studied at the Vrije Universiteit in Brussels, but also studied in the United States, has degrees from, I think, Georgia and George Washington, is that right? Mm-hmm. So really is not just this ignorant, do-gooding European that you've all come to hate in people like myself, but actually has experience on both sides of the Atlantic Ocean. He will speak about customary international humanitarian law, and he knows some things about this because he's the co-author of this big book. And in fact, in a way, we do not only have Jean-Marie Henckaerts here, but we also have this book in the room as a, if you want, semi-official restatement of current international humanitarian law. I say semi-official because, as many of you know, the International Red Cross is the guardian of international humanitarian law, and therefore is out there to protect it, but also to find out what actually it is. So even though this does not come out as an official report of the Red Cross, I understand it still is read very much in that way. So we have Jean-Marie Henckaerts here, we have this semi-official book here, and we have a third thing here, of course, in the room, although absent physically, and that's the surprisingly active responses and quite critical responses from the United States on this. The current issue of the American Society of International Law is reprinting a letter by coming from the State Department, from John Bellinger, whom many of you have seen last year give a talk here, who read about a third of this and already felt the urge to respond to it. The response is very interesting. You see, they say, we haven't even gotten through all the rules, but we already think we should respond, and there are problems with your method, and there are problems with your substance. And of course, this is not just idle theoretical stuff. This is about the rules of how to conduct wars, of how to behave in wars, how nations are bound to behave in wars, and obviously for a nation that sees itself in war, this is directly relevant. This is very important stuff. So this is a very important topic with the best speaker you could have about the topic, I suppose, at this moment in time. So I'm really eager to learn a lot about this. Jean-Marie Henckaerts had said that it's a complex topic, so he will have to speak to many things and in quite some detail, but he will try to leave room for questions afterwards, and I look forward to getting those from you as well. Without further ado, Jean-Marie Henckaerts, thanks very much.
Yes, good afternoon and bon appétit, everyone. It's my pleasure and privilege, actually, to be invited to Duke Law School and to speak here. As you've heard, I've not studied here, unfortunately, but I have studied in the United States, and so I was hired by the International Committee of the Red Cross to undertake this study on customary international humanitarian law. It's quite a long term, but we usually speak about IHL, International Humanitarian Law, or Law of War, or Law of Armed Conflict. So this is specifically about the customary international humanitarian law. I mean, as you all know, the main sources of international law are treaties and customs, so conventional law and customary law. And this, of course, applies to any branch of international law, including international humanitarian law. Now, maybe one difference is that international humanitarian law, if you see on the left-hand side, is an area of international law that is highly codified. Since 1864, numerous treaties have been adopted. I've just listed here some of them. They're not even all of them. Some of the main treaties of international humanitarian law, starting with the first Geneva Convention of 1864, 1907 Hague Regulations, and we celebrate this year the 100th anniversary of those regulations on land warfare, still very relevant in today's armed conflicts, including those in which the United States is involved. The Geneva Gas Protocol, the 4 Geneva Conventions of 1949, the Hague Cultural Property Convention, Biological Weapons Convention. I'm just listing them so that you get an idea of the areas that international humanitarian law, or IHL, deals with. Then importantly, 1977, the additional protocols to the Geneva Conventions of 1949. Protocol 1 dealing with international armed conflicts, and Protocol 2 with non-international armed conflicts. And in Professor Kühner's class afterwards, I will talk more about that. 1980, we have the CCW, or Convention on Certain Conventional Weapons. And this convention now has 5 protocols. There's a Chemical Weapons Convention, Ottawa Convention banning anti-personnel landmines, and the ICC statute, and it even doesn't stop there, it continues. So it's a highly codified field of international law, and that may have made or led people to forget that actually custom has continued to exist in parallel with those treaties. And of course, in certain circumstances, custom may have advantages, and we'll talk about those. Now, treaties are, what treaties are is well-known conventions, but what is customary international law? I think I should speak a bit about that, and also to mention that some of the criticisms raised in the letter by Mr. Bellinger and Mr. Haynes, legal advisor of the State Department and the Department of Defense, they deal quite a bit about, they deal quite a lot with issues of methodology. And so many of their comments, their main comments, are related actually to this. What is customary international law? It's defined in the statute of the International Court of Justice as general practice accepted as law. So I will start with practice. Well, in this area of international law, at least, practice is described. You can find practice in military manuals, in legislation, in case law, official statements, but also, of course, reports on military operations. So it's not really, descriptions of what happens on the battlefield as such, except if they are reflected in these official reports, but rather, official documents that describe how armed forces are to behave. Now, this practice has to be general, which means extensive, and I should actually change this to virtually uniform. This is the formulation used by the International Court of Justice. So you may have lots of practices, for example, that states send letters of condolences when a head of state dies. But, excuse me, I'm mixing up now. So the practice has to be extensive and virtually uniform. That's important. And thirdly, and here is where my letter of condolences will come in, thirdly, these general practices have to be accepted as law, which is often referred to as the opinio juris, the element of opinio juris. And this is to set aside exactly general practices that create legal rules from mere practices of policy, comity, or in the area of IHL, military convenience. So I gave the example of sending letters of condolences, and this is, of course, a general practice, but no one would suggest that this is a rule of law, that there is an obligation to do so. Whereas the customary rules of IHL that we have identified, such as the prohibition to attack civilians, or the prohibition of pillage, or prohibition of sexual violence, obviously, these general practices are rules of law. They reflect rules of law. Now, to be very brief about the criticisms, because this is not the main point of my discussion, but since Professor Michaels has mentioned it, I should just mention a few things. On all these points, of course, people can disagree exactly. As I said, these are mainly documents, and one of the criticisms is that the study relies too much on military manuals and not enough on actual operational practice. And as has been mentioned, the letter will be published, has been excerpted in the American Journal of International Law, but it will also be published in the International Review of the Red Cross. And the difference there is that there will be actually a response by myself. So I'm not able here to summarize my response, but on the various criticisms that Mr. Bellinger has raised, we actually have taken these points into account from the beginning. I mean, we're quite aware that a military manual is a written document, and may not as such, people may not immediately think this is not actual practice, and customary law should be made by practice on the battlefield. And that is not actually correct, because customary international law requires you to balance what people do, but also what they say about what they do. So you cannot just merely look at practice. You have to see how that practice is regarded from a legal point of view. That is why military manuals are so important. In addition, military manuals, of course, reflect what armed forces are taught to do and what most of the time they end up doing. So they quite well describe what is the actual battlefield practice of armed forces. Then, of course, with respect to the fact that practice has to be general, extensive, and uniform, one of the criticisms is that for many of the rules, they find that there's not enough practice. And this, of course, you can say about any conclusion by any court, for example, about a customary rule of international law, that there's not enough practice because there is no mathematical formula. You don't know exactly how much practice you need. And the amount of practice that you will find differs from subject area to subject area. For example, the previous international court, the Permanent Court of International Arbitration, found a rule on the international passage of canals, and they only had two precedents, namely the Panama Canal and the Suez Canal. So on international canals, you actually only had, at that time, two situations because there were only two canals. So is that extensive? No, not really, but there are only two. So the same is true with rules of IHL. I mean, on the prohibition of attacks against civilians, you find lots of practice. All the military manuals deal with it. But on other areas, let's say the protection of the white flag, there is actually fairly little practice. But nevertheless, whatever practice there is uniform, and that's why we have concluded that, yes, these are customary rules. So it's not, I don't find it's a fair criticism. It's easy to level this criticism against any assessment of customary international law to say there's not enough practice. I think that what we have here is volume 1, the rules, but what we don't have here is volume 2, namely the practice, which is 4,500 pages, 2 volumes. And never before actually has so much practice been collected and offered in such a systematized way, and that the assessment of customary law is actually based really on practice, unlike some of the conclusions of international courts and tribunals, which one may say offer fairly little practice when they reach conclusions about customary international law. And on the third point, there is also a criticism, of course, that they say some of the practice doesn't reflect opinio juris. And some things may be in military manuals for policy reasons, and sometimes we may vote for resolutions when we invoke resolutions for policy reasons, not to break consensus and so on. And it's true, you cannot prove for each and every, or for a specific piece of practice that really this is done out of a sense of legal obligation, that it is done because it is accepted as law. But what I'm submitting and what I submit in my response to them is that if you look at the totality of practice, you see, let's take rape as an example, the prohibition of rape in armed conflict, very serious topic. And let's say there's a resolution in the Security Council or the General Assembly, and let's say State X votes in favor of that resolution. You cannot know why they vote in favor of that resolution, unless they would say so. We vote because we consider prohibition of rape to be a rule of law or customary law. But states never do that. But of course, you are not only having that one resolution if you look at this subject. You have lots of practice. There are military manuals, there's legislation, there's case law, there are people who are being prosecuted. So if you look at the totality of practice, and this is what I'm submitting, then it becomes clear that this reflects a rule of law, and whether this or that specific instance really reflects the opinio juris of the state concerned, no one can prove beyond any doubt. So, but it's also not required. You have to look at the totality of practice, and then it becomes quite clear that what you're dealing with is a rule of law. So I've been a bit longer about this because this ties in very much with the letter by the legal advisors that was mentioned before. Now there's one other aspect related to this general practice accepted as law, is namely how do you deal with violations and contrary practice? Because of course I've mentioned some of the examples of customary rules of IHL, prohibition to attack civilians, prohibition of pillage, prohibition of sexual violence, and people might say, well, this happens a lot, so how can you say this is customary? The customary practice is that it is prohibited, and yet it happens. And of course, here we have to distinguish really between violations and official contrary practice. To the extent that what happens on the battlefield are mere violations, then that's all they are. They're violations of existing rules. The International Court of Justice in the Nicaragua case said that instances of conduct inconsistent with a given rule should generally have been treated as breaches of that rule, not as indications of the recognition of a new rule. So the instances of attacks against civilians, pillage, hostage taking, and so on and so forth, use of human shields, all procedures which are acts which constitute violations of IHL are generally seen as violations of IHL. And the parties involved actually often deny these facts or seek excuses within exceptions to the rules and so on and so forth, thus recognizing that actually the rules exist. So violations do not stand in the way or do not undermine the existence of these customary international law rules. And this is also important, what I said earlier, namely that, and in response to Mr. Bellinger, if you say you have to look more at battlefield practice, well, battlefield practice actually doesn't tell you anything. You need to look at the legal qualification, the way the acts on the battlefield are received, because otherwise you might just be dealing with violations. You don't know. Otherwise, if you look at what happens, that's all it is. It's just acts, but you don't know, is this accepted or not? So that's why you have to look at statements. That's why you have to look at military manuals. That's why you have to look at resolutions, because they will tell you, for example, that acts of sexual violence, pillage, and attacks against civilians are unlawful. You see, the actual battlefield practice doesn't always tell you that. You see that people abstain from it in many conflicts, but then you also see that it happens in other conflicts. So in order to understand why they abstain and how people react to when it happens, you have to look at this non-battlefield practice, which is the written documents, the official statements, reflecting opinion juris, and so on. So that is why I said, in order to correctly assess customary international law in any field, you have to look at what states do and what they say. If you only look at what they do, then my suggestion to Mr. Bellinger is that nuclear weapons are prohibited because they're not used. So I deduce they're prohibited. No, the United States would not agree. Why not? Because they have claimed, said, verbal acts that they are still entitled to use them. So the correct assessment is a combination of what happens, non-use, with how is this actual non-use explained. Namely, we haven't used them because we didn't have to, but we do not consider ourselves bound not to use them, you see, or prohibited from using them. Good. So this is the theory of customary international law that, you know, is taught in all the international law classes, but when you actually have to apply it as we did, then it was quite a challenge, and many aspects come into play. So most of, you know, what people can call contrary practice often constitute violations. When there's official contrary practice, when states, you know, say, yes, we do something contrary to a rule which others have accepted, then this means that no custom can emerge because there is no uniform or virtually uniform practice. And a good example is the use of anti-personnel landmines, where a number of states, United States, Russia, China, Finland, India, a number of states say, yes, we use anti-personnel landmines, we need them, Korea, and so on. So there is a treaty, the Ottawa Convention, banning anti-personnel landmines, but that treaty does not reflect customary international law because more than 100 states have ratified it, abide by it, but a number of other states, a large number of other states, do not accept it. But this is quite different, you see. This use of landmines, open and acknowledged and official, if you like, that's why I put it in quotation marks, is quite different phenomenon from attacks against civilians or acts of pillage which are violations of international humanitarian law. Good. So these are the more theoretical aspects underlying the study, and if you have questions or comments about it, I hope we can talk about it. Now, the purpose of the study, why in 1995 we were requested to undertake a study on customary international law, is related to two of the main impediments to the application of treaty law. The first one, obviously, is lack of ratification. I mean, I've shown you a list of ICHL treaties. These are not all universally ratified, and so that means that in different armed conflicts, different treaties will apply. And of course, states wanted to know, well, what are the customary rules that apply in any conflict, regardless of treaty ratification? Secondly, and most importantly, NIAC treaty law on non-international armed conflicts, on internal conflicts, is rudimentary. The items I've listed here are actually not specified specifically in the treaty law governing non-international armed conflicts. Issues on the conduct of hostilities, another example, protection of journalists, numerous aspects of the implementation, war crimes regime, command responsibility, and so on, is not specified specifically in Additional Protocol 2, which is the main treaty governing non-international armed conflicts. Because when the study was mandated, this was in 1995, after genocide in Rwanda, a non-international armed conflict after wars in the former Yugoslavia, Bosnia-Herzegovina, non-international armed conflict. Actually, Rwanda and Yugoslavia had ratified almost all treaties, so Impediment 1 wasn't really relevant in that context. But notwithstanding them having ratified all these treaties, states found that they didn't actually find all the answers relevant to non-international armed conflicts. And so also wanted to know whether maybe customary international law contains a more detailed normative framework for non-international armed conflicts. And as I will present later, indeed it does. So if we compare treaty law to custom, of course, the advantage of treaties is that they're written. The disadvantage is they require ratification, and as it so happens, treaty law in IHL contains less rules governing non-international armed conflicts. Custom, on the other hand, unwritten, and so in a sense, the purpose of our study was to write down what was unwritten, or to describe, if you like, what is unwritten. It is of universal application, except in cases of persistent objection. And the outcome of the study is also that we did find that there are, in fact, more rules governing non-international armed conflicts under customary international law than in treaty law. And this is extremely important conclusion, because most armed conflicts today are of a non-international or of a non-international character, excuse me. So it's quite a paradox that you have lots of treaty law, which is the 4 Geneva Conventions, extensive and detailed rules governing international armed conflict, but actually there are very few international armed conflicts. I mean, wars between Eritrea, Ethiopia, invasion of Afghanistan or Iraq are actually exceptional. Most conflicts today ongoing in Colombia, Sri Lanka, Nepal, Philippines, South Thailand, Georgia, sometimes dormant conflicts, Darfur, conflicts, most conflicts in the world today are of a non-international character. And so it is very important to actually have that more detailed normative framework. I will give some examples later on of the practical uses of customary IHL today, and as a consequence also of the study we've produced. The characteristics of the study, which I think are important to underline to realize where we come from, is first of all that this is at the request of states. It's based on an international mandate that was formulated first in January 1995 by a group of experts for the protection of war victims, and then approved by the 26th International Conference of the Red Cross and Red Crescent, at which all states participate. I mean, this is not just a Red Cross, Red Crescent conference. All states party to the Geneva Conventions participate in this conference. So states approved of this mandate to the ICRC to carry out a study on customary IHL. And you see, January 1995, this group of experts was convened in the face of the massive violations of IHL in the former Yugoslavia and in Rwanda, and to come up with solutions and answers to better implement international humanitarian law. You must remember, at that time, there was no international criminal court. There were no ad hoc tribunals. Most states did not have legislation, national legislation, which would allow refugees from those conflicts, but which had committed war crimes, to prosecute them. So there wasn't really much in place yet to effectively enforce international humanitarian law. And so the group of experts came up, gave a number of recommendations, and one of them was that the ICRC carry out a study on customary IHL. So this has been published in 2005, so it seems like 10 years, but actually it took us 8 years to conclude the study, because we started then in 1996, actually, after the international conference. And when we published it in 2005, of course, in the meantime, the world had changed, and the customary IHL became particularly relevant in other parts of the world, outside those for which it first was, that first created the need for it, which was Yugoslavia and Rwanda. Second characteristic, and also important to underline, that this is not really a study, just the ICRC or just the 2 co-authors or co-editors. There were many other people involved. I will not go too much into detail with it, but just to underline that we did all these reports and tried to collect as much practice as we could. And in total, in fact, we have collected practice from more than 150 states. So therefore, also, I find the criticism that there is too little practice a little bit well, unjustified, of course, from my point of view. It's at least, and also the 8 years of research shows that it was the best effort we could do, and we involved about 150 experts and professors all over the world to really produce an accurate picture of practice, so that the rules that would be based on that practice actually reflect reality and would not just be seen as wishful thinking of what the ICRC or the Red Cross would want customary IHL to say, but which does not actually reflect reality. We also finally consulted governmental and academic experts around the world on the final results. Thirdly, and I will not speak very long about this, just the inductive methodology, of course, which means that we first completed this volume 2, which are the 2 books that I mentioned, 4,500 pages containing practice. So for each topic, let's say pillage, you will find in volume 2 a chapter on pillage containing excerpts from military manuals, national legislation, case law, resolutions, all dealing with pillage. And on that basis, you will find in volume 1 a rule then saying pillage is prohibited, which then in a commentary summarizes, the considerations why there is a general practice accepted as law supporting this rule. So in fact, historically, volume 2 came first, and volume 1 is built on it, because because of the definition of customary international law, it has to be an inductive methodology. Now, the outcome of this, in this particular study, we have identified 161 rules, but this doesn't mean that there are only 161 rules of customary IHL. I mean, there's still other rules out there. These are 161 issues, topics that we looked at, and we were, so it's a random figure, if you like. We could have looked at less things and came and have finalized the study on 59 rules, or 63, or 74, or 165. I mean, it just so happens in the time frame that we had, we looked at these topics, and we came to the conclusion that 161 rules existed. And for some topics we discuss in the commentary, we also found that certain things were not customary, you see. Now, the rules are all listed here in this little booklet at the end. You have a list of rules, which is actually not included in the book. The book starts with rule 1 and then commentary all the way down to rule 161. The article at the end has the list of the rules one by one. Now, I cannot go over all the rules, of course, but if you read them, they really represent sort of the basic fundamental rules of IHL. There's nothing new, of course. Customary international law is not new. It's based on existing practices. But a general overview of the rules is just to indicate where they apply, in which types of conflicts. So of the 161 rules, 13 of them apply only in international armed conflicts. And these are rules limited dealing with issues such as occupied territory, combatant and prisoner of war status, which are typically concepts that only apply in international armed conflicts. Then there are 2 specific rules only applicable in non-international armed conflicts. A rule on the prohibition of reprisals in such conflicts, and a rule on the granting of amnesty at the end of such conflicts. But the majority of rules, 146 of them, apply in any armed conflict, so both international and non-international. And this, of course, goes a long way in overcoming the impediment that I mentioned earlier, that there are fewer treaty rules governing non-international armed conflicts. Well, in fact, here we've already identified 146 plus 2, 148 customary rules applicable in non-international armed conflicts. And this is extremely important. For on a daily basis, we actually need these rules, and they are being relied upon by armed forces in the conduct of military operations, by NGOs, by governments, by the UN, by the Red Cross, in fact. So I'll give a few examples of how this customary international law can come into play, into practice in military operations, in fact-finding, and more legally in judicial proceedings. So in military operations, of course, in international armed conflicts, you have the situation where a state has not ratified Additional Protocol 1, the main treaty dealing with the conduct of hostilities. For example, the war between Lebanon and Israel. Since Israel has not ratified this Protocol 1, all the interventions on the conduct of hostilities, where dealing with indiscriminate attacks, dealing with attacks on Beirut, whether there was disproportionate damage and so on. All these interventions had to be based on customary international law because you could not invoke the relevant treaty provisions since they weren't ratified. So as a result, you see reports from the UN special rapporteurs who went into southern Lebanon to investigate certain things, referring to customary international law and referring also to the study. In non-international armed conflicts, so as I mentioned, the majority of armed conflicts today, you similarly have situations where the main treaty dealing with non-international armed conflicts, Protocol 2, is not ratified. For example, Sri Lanka. So in those situations, only as treaty law, you can only invoke common Article 3 of the Geneva Conventions, the only provision of the Geneva Conventions applicable to internal conflicts. So very little treaty law. So you cannot, if you have to intervene with the government or the rebel movement about conduct of hostilities issues, you don't find anything in Common Article 3. So again, customary international law does contain a number of rules. Not only conduct of hostilities, but also, as I said, implementation, protection of journalists, but such practical issues as the recording of the personal details of detainees so that people do not go missing, the return of dead bodies to the families, and so on. Very important practical issues that do not find answers in Common Article 3, not even in Additional Protocol 2, actually, for some of them. You can rely on customary international law, and this is being done now. A country that has ratified Protocol 2, like Colombia, still, as I mentioned earlier, treaty law does not contain certain things, lacks content, again, dealing with issues such as the conduct of hostilities. So even in those countries, we are relying on customary international law. I mean, in Sri Lanka, customary IHL is really the talk of the day. I mean, we had a specific launch event there with Judge Veeramantri of the study. And then this year, because of the 100th anniversary of the Hague Regulations and the 30th anniversary of the protocols, we had another event, again, where he spoke about customary international humanitarian law. So we see that in conflicts around the world, today, current conflicts, custom continues to be relevant. I mean, and to give examples relevant to the United States, of course, in Afghanistan, in Iraq, and also in the military operations in Somalia, custom continues to be relevant because in none of those three contexts, the additional protocols are applicable, since the countries involved have not ratified them. In fact-finding, we have a few examples. This is an example before the study was published, but just to show you when lawyers need to rely on custom. This is the ICTY committee established to review the NATO bombing campaign against the former Yugoslavia in 2000. They could not rely on Additional Protocol 1 because not all member states of NATO had ratified it. So as a result, this committee had to rely on customary international law. Could only rely on customary international law, excuse me. Similar thing happened, and this was an international conflict, in an internal conflict as recent as 2004, 2005, the International Commission of Inquiry on Darfur, which reported to the Security Council and which then referred the situation of Darfur to the International Criminal Court, had to rely on customary international law to a large extent because Sudan had not ratified at the time Additional Protocol 2. So to assess the legality of acts happening in Darfur, forced displacement of population, acts, use of sexual violence as a weapon of war, maybe starvation, destruction of civilian property, attacks against civilians, and so on. The Commission had to do this on the basis of customary international law. I mean, I find this it's quite amazing. There are so many treaties, and then at the end of the day, when a commission is established, it can't use the treaties, and it has to rely on custom. So it's quite, so custom continues to be of use. The same in judicial proceedings. I mean, the Israeli High Court of Justice had several occasions to rely on customary international law. Most recently in a very famous case of December 2006 when it reviewed the legality of the IDF practice of targeted killing that you may have heard of. And so since Israel is not a party to Protocol 1, which is the treaty containing most of the answers to the problem, most of the answers to problems of the conduct of hostilities, the court had to rely on customary international law and cited the study and cited with approval a number of rules. In international courts and tribunals, similarly, I will not talk long about the nuclear weapons case. This was a case of 1996, before the study came out, of course. But again, the court could not rely on treaty law there because not all the treaties are ratified by all UN member states. And since it was an advisory opinion for all the members of the UN, the court had to rely on law that binds all members. So it had to rely on customary international law. More recent example is the Hadziadzanovic case before the ICTY, where in both two phases of the proceedings, the court relied on custom first to see whether the issue of command responsibility, whether a commander is responsible for war crimes committed by his subordinates, whether that concept exists in non-international conflicts, because this was a case related to the conflict in Bosnia and Herzegovina. So Yugoslavia has ratified Protocol 2, but Protocol 2 doesn't contain any answers. It doesn't deal very much with implementation, and it doesn't say anything about command responsibility. So the court indeed looked at custom and established, concluded similarly to the study that indeed there is command responsibility in non-international conflicts. And then on the merits, the court also looked at custom to see whether the specific acts charged, namely destruction of civilian property, attacks against civilians, and also attacks and destruction against cultural property are customary, because the specificity of the ICTY is that its statute, Article 3 of the ICTY statute, gives the court jurisdiction over violations of the laws and customs of war. So for many of the acts charged, all the acts charged under this Article 3, the court has to establish that indeed the acts charged are violations of customary international law. So you see that now increasingly, and in the Hadziadzanovic case, this was the case, the court increasingly cites practice, to reach its conclusions. And it cites practice because now practice is more easily available in the study that we've produced. And a final example is on arbitration, where once again we have a nice example with the war between Eritrea and Ethiopia. And at the time the war broke out, Eritrea was not a party to the Geneva Conventions. Today it is. And so was also not a party to the additional protocols. So the Eritrea-Ethiopia Claims Commission also had to rely almost exclusively on customary international law. Even issues such as the treatment of prisoners of war, the Commission could not rely as such on the Third Geneva Convention because Eritrea was not a party. On issues related to the conduct of hostilities, the Commission could not rely on Protocol 1 because Eritrea was not a party. So what the Commission did was, for the Geneva Conventions, it said, we'll assume they are customary, because almost all states are a party, except at the time Eritrea, Nauru, and one other state, I forget. Maybe only Eritrea and Nauru, 2 states. So we'll assume they're customary. And if anyone objects, if either party objects, they have to prove, they have the burden of proof that it's customary. So neither party ever objected, and so this was accepted. With respect to Protocol 1, the Commission also said this is customary. We'll assume it's customary. But if either party objects, then it's the Commission's burden of proof. The Commission has the burden of proof to establish that the provision in question is customary. And there is one interesting claim before the Commission dealing with an aerial attack on a water purification system near the Eritrean capital Asmara, so carried out by Ethiopian Air Force. And so I assume from the proceedings that there was an objection when the Commission then relied on Protocol 1 to assess the legality of this aerial attack, relied on Protocol 1 as customary international law. And so the Commission, in its award on this aerial attack, then examined and concluded that indeed the specific provision invoked of Protocol 1 is customary. So you see that in conflicts around the world today, a custom continues to be relevant, notwithstanding the high number of treaties that exist. So in conclusion, obviously, customary IHL is a source of IHL, and anyone studying any area of international law and only looking at treaty law, of course, is only looking at half of the picture. I admit it's not always easy to know exactly what is the other half, and that was sort of the purpose of this study, to help states to clarify that other half of the picture. This particular study then that we did identifies 161 rules, most of which apply to international and non-international conflicts that I've explained. And so one of the main outcomes then is that the divide in the regulation also between IHL rules on international armed conflicts and those on non-international armed conflicts is closing, namely that, but not closed. So there's still some rules that are different, obviously rules relating to occupied territory, treatment of prisoners of war, prisoner of war status, competent status. But the main rule, the basic rules on the conduct of hostilities, on the use of weapons, on the use of means and methods of warfare, and on the treatment of persons in the power of a party to conflict, indeed today are the same, whether the conflict is international or non-international. And this, of course, is a very important conclusion and will help a lot, I hope, in the implementation of IHL and in the dissemination of IHL in practice. Thank you. Sorry? No, I'll stand. Are there any questions? I realize it's quite dense. Normally I need an hour for this, but I try to leave some time for questions. Yes?
I have a question for you. The criticisms directed at this study seem to me to be based more on the methodology than the content, because I'm looking through these 161 rules, and there doesn't seem to be much of a difference between Field Manual 2710 or any of the other military manuals that the United States follows and these rules. So do you think that it's more directed at what may come in the future from following this methodology of customary international humanitarian law, or do you think it's levered at some intrinsic thing in the study itself? Some rule that the State Department just does not like?
Well, I think first, as I understand it, of course, and understand the legal advisor's position is just to make a reservation to say, you know, this, we do not accept this as such. This is not as such binding on us, and that's obviously clear. I mean, it's an academic study, so it's not a source of law. It's not a treaty. It's not actually custom. I mean, custom exists, and this is a description of what we think custom is. You see, there's a very slight nuance. So the United States just want to say, hold on, we do not automatically accept all of this, and we have to review each rule on its merits. And so I think they make a general reservation, if you like, to say we still have to judge each rule on its merits to see whether we agree with it or not. Because then in the letter, and I have it here with me, and if someone wants a copy, you can take it here. They single out 4 rules that they say, based on our comments on the methodology, you see these 4 rules are obviously not correct. And some of those comments I actually agree with. I mean, one rule that the first rule they comment on is rule, just to give you an example, is rule 31. You see, humanitarian relief personnel must be respected and protected, and you might think, well, does the U.S. have a problem with that? No, not as such, but they say it's not enough. It has to say that the humanitarian relief personnel, when acting as such, they don't step outside their mission if they actually are humanitarian relief personnel and not doing something unlawful, and if they are operating with the consent of the state concerned, and if they are not actually taking part in the hostilities themselves. So. And we all agree with all of that, and we say, well, the commentaries actually talk about that, talk about the issue of consent. There is another rule saying that civilians lose their protection if they take a direct part in hostilities. So if you read the 2 rules together, that's Rule 6. If you read Rule 6 and Rule 31 together, you actually come to the same conclusion as the US letter. So they say we oversimplify some of the rules, like this Rule 31, and therefore it's not an accurate description as such of the rule of customary international law. So we have, you know, some things like consent to humanitarian relief operations, which we think is necessary, is required, but we have actually discussed it in the commentary. That was just a choice. There's also, of course, a level of difference between the legal, you know, how do you say that? Yeah. I mean, with this list of rules, this has been translated in more than 30 languages, and you cannot go into that level of detail all over the world, and this is being disseminated, you know, all over the world. I mean, as I was flying here, my colleague was going to London to go to Khartoum and there take another flight inside Sudan, and then from there another small flight into the mountains, and from there by jeep higher up in the mountains she's going to disseminate IHL to rebels in the Darfur crisis. I mean, there you cannot come with that level of detail. Obviously, so I agree, the rules have to be stated correctly, but I still find it, after all, and I've thought a lot about this, because there's always this risk when you write as a black letter rule, a rule of customary international law. You try to capture it, and then maybe you do not capture it exactly, But I still find at the end of the day it was useful to write it down and to try and capture it, to be able to present a list that you can disseminate, and to not make that list overly complicated, while acknowledging to the specialist audience, yes, there is an exception to this. If the humanitarian relief personnel does this or that and so on, there is the issue of consent, but those detailed discussions are addressed in the commentary. So I think the letter is served also basically, to come back to your question, as a general reservation, if you like, for any other rule that in the future we might invoke vis-à-vis the United States, or any other government might invoke vis-à-vis the United States, that they would be able to say, listen, we've never formally accepted this study, that all of the conclusions are correct as such. Another rule that is discussed, but you can read the details of that discussion, is a rule on weapons, and it gets very, very detailed. It's Rule 78. Anti-personal use of bullets which explode within the human body is prohibited. So this is the prohibition of exploding bullets. So it's, I shoot a bullet at you and normally you get wounded, you're out of combat, and that suffices. But these bullets explode within you, and they're actually meant for anti-vehicle use. To shoot at a tank, they can pierce a tank and explode within the tank. There is not as such a military necessity or use for me to put you out of combat by making you explode. So they are not as such against the concept that of the prohibition of exploding bullets, but they would like the formulation to say, or the rule to say, bullets which are designed to explode within the human body. And this reflects a discussion that, anyway, the ICRC has had for many years with the United States and other governments about the exact meaning of this prohibition, whether the bullets should be designed as such, or whether it suffices actually that they do explode. Our position is that we should look at, if they explode, and they explode most of the time.
Well, that's the CIA, is of course listening.
If they explode most of the time when they hit the...
Let me turn this off and see if you can...
Oh, it's okay.
Yeah?
Just touching... You see, they say the bullets have to be specifically designed to explode within the human body, but I would say, how can you prove that intent and why is it necessary? If they in fact happen to explode most of the time, then probably that's something related to the design. Whether you wanted that or not is actually less important. So again, it's a very detailed legal discussion about a formulation of the rule, and not as such I find that we actually disagree on the substance of what the rule is meant to do. Thank you. Other question? Yes?
To what extent, for a country to reserve out of customary humanitarian law, does their actual practice on the battlefield factor in terms of, if a country's practice, like, for example, targeted killings or using these exploding bullets are, often in combat situations used and continuously used, is that enough for the country to indicate their disagreement with that area of customary law, even if it is customary law, or do you also at the same time have to actively write letters of disagreement with those laws?
Well, I don't think the letter here is meant to to serve as a persistent objection to all of the rules. It's just to say that we do not necessarily agree with all of the rules and not necessarily agree with them as they are written. What you're referring to, if you want to opt out of customary international law, it's indeed through persistent objection during the formation process of the rule. So you cannot opt out later on. There's no subsequent objector rule. There's a persistent objector rule, so you have to object very important. You have to object from the beginning and persistently. And actually, on those matters, we see very few of those instances. And this should not come as a surprise, because customary rules reflecting a general practice are actually good rules. They make sense. They have been tried and tested. That's what they are. They're the common sense rule that armies around the world who've had experience have adopted, have put in their manuals, in their instructions and so on, that they've actually followed. And if they weren't followed, there have been prosecutions and so on. So there is generally no need for a state to say, wait a second, I don't agree with the protection of the white flag. I would like it to be a red flag that should be used. See that kind of thing. Or I don't think that, that the prohibition of attacks against civilians is valid for me, because in the way we conduct warfare, it's total warfare, and we want to be able to target everyone. There is no need for any state to do that. So we have actually very few cases of persistent objection. In the study itself, we address it in one rule, and this is, so I've mentioned already humanitarian relief personnel, I've mentioned the exploding bullets. The third rule that is singled out in the letter by Mr. Bellinger is rule number, it's dealing with the environment. It's rule number 45. Use of methods or means of warfare that are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment is prohibited. In that context, we point out that, first of all, we think the United States, France, and the UK are persistent objectors with respect to the application of this rule to nuclear weapons. What Mr. Bellinger says, and I agree, is that as a result, not only are they persistent objectors, but that rule has not matured into a customary rule as regards nuclear weapons. This I have already admitted in other conferences. So also in my response, I again admit that indeed, since there are several persistent objectors, so there is no virtual uniform practice, and this is practice from important states, particularly relevant states, so indeed the rule does not apply with respect to nuclear weapons as a customary rule. Then we also say, for this specific rule, that the United States maybe is a persistent objector generally to this rule, and in their letter, indeed, they say that, yes, we are. We do not think that this rule is customary, and certainly not for us. So that's the only place in the whole study in 161 rules where we talk about it. Because usually what happens, indeed, is it's not an issue of a persistent objector and the rest goes and create a customary rule. It's that there are many objectors, and so there's several countries that have contrary practice, and as a result, there is no customary law rule, you see. Like with the anti-personnel landmines, it's not just the United States, it's Russia, it's China, it's Finland, it's Korea, and a number of other states, Poland, still using landmines, anti-personnel landmines. So rather than saying there's a custom for all the others, and there are like 15 persistent objectors, no, it's contrary practice from a number of states, and as a result, there isn't a customary rule. So persistent objector really is limited to cases where one or two states maybe, opt out from the very beginning and persistently, and it's very rare.
I think we might have time for two more questions if we can
combine
sure. Those and then have a brief answer. Perhaps Aaron, then you.
Following up on Josh's question, so you're saying like the United States and India, we are opting out of the exploding bullets. But that's only 15 countries. And so when does, what level of consensus has to arise? And does it matter what countries are the ones that are objecting? If it's tiny countries that people don't care about, does that mean, but the fact that the United States and India and Russia, does that play a part in what becomes custom?
Yeah, this is a...
We'll hear both questions.
Oh, okay.
My question is very precise. In answering the exploding bullets question, you referred to the difficulty of making it a simple statement and understandable in all the language you talked about. And yet you had no difficulty over in Rules 86 on laser weapons in saying that they must be specifically designed to cause blindness. And I wonder why the lack of precision in one case and not in the other.
So that's two almost completely unrelated questions.
Yeah, two very good and difficult questions. indeed, this is also, and I recommend you read what they say and what I respond to, because in the continental shelf case, the International Court of Justice has mentioned that a treaty can become custom in a short period, but provided that states, especially affected states, have accepted the treaty rules. So now many scholars say that custom always has to include specially affected states. And in my response, I have not fully analyzed it, but I've started to think about it, and I think the court said this only for the law of the sea and only for a not widely ratified treaty. And in the law of the sea, it's pretty obvious who are the specially affected states. I mean, if you're dealing with archipelagos, for example, it's the archipelagic states and so on. If you talk about coastline, it's the states who have a coastline. But what about international humanitarian law? I mean, are the specially affected states the states that are involved in armed conflict? Or do not all states have a special interest? Because tomorrow, your state may be attacked by your neighbor, by another state far away, and so on. So I don't have the answer, and I would suggest the law professors here to ask some law students to write theses about it, the concept of specially affected state. I mean, the United States has made this argument. You know, you list the manuals of Togo and Benin at the same level of the military manuals of the United Kingdom and the United States, and the United States is much more important. So the military manual should count more than those of smaller states which have not had operational experience with armed conflict. Well, first of all, I'm not so sure about that because many African states contribute peacekeeping forces. So, but anyway, because Togo could become involved in an armed conflict, so its practice and the state itself may have an interest actually in making sure that nuclear weapons are regulated in one way and not the other, that exploding bullets are prohibited, and not because, even though it's not currently involved, it may become involved. So I'm not sure that you can mechanically transport the concept of specially affected state from one area of the law to the other, and that the International Court of Justice meant this to apply to all areas. But, as they say, and as I agree, of course, states that have been involved a lot in armed conflict do contribute a lot more practice, yes. If you look at Volume 2, even at Volume 1, the United States is mentioned all over the place, because obviously it has, because of its practice and its involvement in armed conflict, expressed opinion, written memoranda, and so on and so forth on numerous aspects and given interpretations on almost all the aspects. So yes, it has contributed a more important quantum of practice and qualitatively more detailed amount of practice. But from there to say that that practice should count more than that of other states, that, you see, is I don't know whether that's correct. Now, with respect to your question, basically it's, with the anti-personnel landmines, it's easy because there are so many states that do not accept it, so you can clearly say it's not uniform. But there are not as such cases where only 2 minor states would object to any of these rules, basically. So the question in that sense is theoretical. Again, because they don't need to. These are the basic rules of IHL that have been tried and tested that make sense from a military and humanitarian point of view, and so there's really no need as such generally for any state to opt out or to persistently object. With respect to blinding laser weapons, indeed, you see Rule 86, we're not going to disseminate that in Darfur because the rebels, frankly, they don't have the technology to produce blinding laser weapons. What this reflects is, the Rule 8 on the exploding bullets, that comes from the St. Petersburg Declaration of 1868, I believe, and that contained a formulation which actually, over time, practice of states has changed in the sense that it prohibited all explosive devices. And what we see now is that states have developed devices that explode for anti-material use. So the treaty formulation in the St. Petersburg Declaration is no longer an accurate reflection of custom. This Rule 86 is a treaty formulation in Protocol 4 to the CCW, and that treaty formulation, you see, has informed the customary process. So we have actually copied here a treaty formulation, and that's why it's more detailed and more specific. I mean, you find that for many rules. If you look at Rule, it's a very good example, Rule 8, which is the definition of military objectives, It's a very detailed rule, but it's literally a copy of Article 52 of Protocol 1. So this is an entire, another hour's presentation, namely to discuss the interrelationship and the exchanges that happen between treaty law and custom. I mean, normally you have practice creating custom, which is then codified in treaties. But you may also have treaties which generate new practice, which then become custom. So detailed treaty rules can also become customary. So there are a variety of rules, such as the one on exploding bullets, which is different. Time out. Which is different. Just one sentence, which is different from the treaty formulation, and another rule which just follows literally the treaty formulation.
We're very sorry about that. I'll have to teach in this room next spring, and I'll make sure that...
No, but we're out of time. So I have here the two letters, the letter and the response, if you want to have a look or take a copy.
Are those online? Yes.
They will be published in the International Review of the Red Cross, as I said, in the next issue, which is the June 2007 issue. So coming out very soon, and the review is online. Yeah.
We have some more documents online actually on the Import website, but apparently this room won't deserve itself, so let's respect it.
No, that's